Park and Park, Mr. Zandy and Ms. Petrie.
Yes, Your Honor.
There we go.
Technical difficulties, Your Honor. Give us just a moment.
Thank you, Your Honor. I'm sure Your Honor has reviewed the pleadings and everything. The motion for reconsideration filed by Mr. Zandy's client was denied, and the denial was entered on May 30th. At that point, we indicated that we would be filing this motion on June 5th if we didn't receive payment for the past due support. We had to wait to file because my client lacked the funds for the motion, but we finally filed and he was served on June 28th. He didn't follow the court order requiring direct payments, but rather dropped a check to his attorney's office, which allegedly stayed there for 15 days. Regardless of the fact that he is current, it took several emails and the filing of this motion to force his compliance with the orders. And my client did not and does not have the disposable funds to enforce this order. She should be reimbursed for this motion. So while Mr. Park is current in support as of today, we are seeking attorney's fees for this contempt.
Mr. Zandy?
And thank you, Your Honor. As court's aware, I do represent the petitioner, non-moving party to the motion, Dennis Park. I think it's pretty clear as to what happened. This is a case, I think factually everybody kind of agrees. We were in court on the motion brought by Ms. Park for spousal maintenance. That was the loan issue that was not resolved under the terms in the CR2A agreement. Judge Evans at the time did order maintenance to be paid. And we did file a short time thereafter a motion to reconsider, not knowing if certain elements of the motion were clear or the response were clear. That was determined to be denied again by Judge Evans. Order was entered as drafted. My client and I met, went over that, stated the need to pay the support. He did that. I think where this gets caught up is in the time between the order being entered on May 2nd and the motion being reconsidered being filed on May 30th. My client meets with me a short time later, issues the check. To Ms. Petrie's point, it did sit downstairs at my office for a period of time and basically crossed in the mail with the contempt motion. It happens, it's unfortunate, but that was the reality of that. My client hasn't intentionally disregarded the order, rather wanted to see what the outcome of that motion to reconsider was. I had the check timely and pursuant to my direction. We submitted that, and unfortunately about the same time they got the check, we got the contempt motion. It is what it is. Also have further information that my client did provide the $1,300 at the beginning of July. Again, pursuant to that order, he recognizes that he did what he was supposed to. And again, this is a motion that, in my opinion, if this is about fees and costs, probably should have been determined or consolidated with the trial that we have set for 2 weeks from now. It's a week of trial. The only remaining issue is maintenance. It would have taken a very short period of time just to consolidate that, address it at that hearing. So I think given the circumstances, the argument that, well, she didn't have money to do that back during the time, again, falls flat, given we are right on the verge of having this matter adjudicated in a couple of weeks. That's our position. Again, I think my client has not intentionally violated a court order. It was just a timing element, issue, an element involved in that. And here we are. He's current. Everybody's on their way, and we have trial in 2 weeks. And we're asking you to deny the motion.
Ms. Petrie?
Your Honor, I find it rather disingenuous that he still waited, even if the timeline being reported by Mr. Zandy is true, he still waited for 2 weeks after the entry of the order denying his motion for reconsideration before he dropped off a check. He knew this was coming. He should have been standing by, and he still waited 10 days or 15 days. So it's, it's not consistent with what actually happened. So we did have to prepare this motion. We did have to file it. And we're going to court on the sole issue. We're going to trial on the sole issue of spousal maintenance. So I didn't want to have to argue attorney's fees and contempt then. It doesn't make sense to burden the court with extra issues at trial when we can resolve this right now. I asked Mr. Zandy did request that I drop my motion, and I asked his client to agree to pay some fees. His client refused.
Okay, well, the two salient points to me are, number one, obviously the filing of the motion for reconsideration doesn't stay the prior court order. He still owed the money and delayed. And B, the check got cut and was put in council's hands prior to the show cause motion. So what I'm going to do is I'm not going to deny the motion for fees, but I am going to leave it for the trial. And the trial judge has a much clearer picture of both parties' finances than I do, just based on the information in front of me. So I'll leave Ms. Petrie's request for fees open for the trial court to consider on the 25th. And do we have
Thank you.
Stephen Mortensen?
Yes, I'm here, Your Honor.
And Ms. Melissa, has the money been paid?
No, Your Honor, as with clockwork, Mr. Mortensen is paid $200 as opposed to the $1,500 that's been ordered by the court. I think this is our sixth hearing in this matter. Previously, Judge Evans has ordered Mr. Mortensen to provide a budget as to why he can't pay. He provided a budget. Judge Evans questioned that budget, indicated it was grossly inflated. And here we are again with $200 in payments for the last 2 months as opposed to $1,500 per month. At this point, unfortunately, given the fact that we've been here 6 different times, this has been pending for 7 months. Mr. Mortensen has been fined with significant sanctions and attorney's fees. That seems to have no effect on him. So at this point, I'm asking that he be ordered to report to jail.
Mr. Mortensen,
Yes, sir.
what do you want to say?
I submitted a budget. It's a good budget. I was just informed about a week and a half ago that my rent is going up at the end of August, and I'm doing what I can. I work every day, and I have bills, and I don't have an attorney because I can't afford one in this case. I don't know what else I can do to satisfy this $1,500, which, as far as I can consider, it's completely unfair, considering that Mrs. Mortensen ended up getting all the proceeds from the sale of the house and all the furniture, and I'm just trying to live and make it, and I don't know what more I can do. I can't get overtime. I can't get a second job. I'm too old for that, and I've been there and done that, and I'm doing the best I can right now.
Ms. Bliss?
And Your Honor, the court found back in September of last year that my proposal of $1,500 a month in spousal support was appropriate given the financials provided. He never filed a motion for reconsideration or anything, hasn't filed a motion to modify that order, just simply chooses not to pay it. I don't know what else we can do at this point.
Mr. Mortensen, whatever bills you've got, you only have one bill that can put you in jail if you don't pay, and that's this one. You think maybe that ought to be your priority?
I guess you do have a point.
I think I do.
Yes, you have a point.
Okay, well, here's where you're at. You're lucky because I'm just filling in today for Judge Evans. If that were not the case, I would be putting you in jail today. Do you understand that?
Yes, sir.
So I'm continuing this 1 week when Judge Evans will be back here. I would assume that if we are in the same position we are in today, Judge Evans will put you in jail. I don't know how to make it any clearer to you or to make you understand the jeopardy that you are in. My assumption is that if we're in the same position next week, you are going to jail. So you should prepare yourself. That understood?
Yes, sir.
Okay, review at the 25th at 9 o'clock. I suggest you figure out how to get this paid. All right, counsel, go ahead.
Thank you, Judge.
And thank you, Your Honor. As court's
Thank
aware,
you,
I do
Your Honor.
represent the respondent and moving party to the motion before you today, Tana Lee. My client is the current wife of the petitioner and the mother to their 3-year-old child, Abigail. My client is requesting the relief in her motion be granted given concerns related to number one, the parenting plan. I think that's kind of where everything originates. Secondary to that are some financial issues that we're asking for the court's direction on it. We go through this temporary process until these parties can get on and through the final divorce. Specifically, my client is asking the court largely for the status quo. I would call it the status quo plus as it relates to the parenting plan. My client has traditionally been this child's primary caretaker. Mr. Lee has traditionally been the breadwinner of the family, entrusting my client with not only the care of 3-year-old Abby, but also the care of his 2 older children from a prior relationship, Landon and I believe Jacob. My client details for you that she has been a stay-at-home mother throughout the course of the 10 to 11-year relationship, caring for not only the 2 older children, but more recently, Abigail. Mr. is employed in a dual capacity, number 1 by the Cowlitz County Sheriff's Office, and number 2 as a National Guardsman, giving service at least 1 weekend per month from what we understand. Since these parties separated last October, and again, we're going on a significant period of time, my client details for you that she's had the child upwards of 80%. If you calculate that out and she provides you calendars and schedules, it actually shows about 83% of the time and overnights the child spent with my client, compared to about 17% to Mr. Mr. Again, we understand generally works a Tuesday through Friday shift to the sheriff's office, and then his National Guard is full weekends, we believe the first weekend of every month. In addition to that, he began a relationship around the holiday season in which he was frequently, or at least 3 weekends of his time, going to Texas to pursue this new romantic partnership with an individual he had met down there, which again takes further time away from him and the child. My client has given you the calendars. Again, we were somewhat surprised on response to learn that Mr. Had stated that it's been close to joint. The reality is it hasn't. The reality is his work schedule and his National Guard schedule and his romantic partnership with this other individual has resulted in him not being anywhere near able to have this child 50% of the time. So looking at that, my client has indicated and provided a proposed parenting plan that she believes will not only work for the parties' work schedules, but also promote for this child's best interest, which largely maintains the status quo that these parties have operated under for the better part of the last 8 months or so. My client's also willing to give the Mr. Lee more time. Again, it's not my client's goal to pull back on any of that or to reduce time or make it difficult for him to spend time with his daughter. This little girl loves both parents. Again, that's positive. Now, my client's simply trying to fashion something that works, and we believe we've done that. We are agreeable to Mr. Lee having visitation every 2nd, 3rd, and 4th weekend from Friday to Sunday. We're also agreeable to some kind of visitation, including overnights on that weekend, the week after the weekend in which he's in the National Guard, from a Sunday to Tuesday arrangement. That equates to about 8 to 10 overnights per month. Again, that is more than he's been exercising since October. Gives the child ample time with dad, also recognizes his work schedule, and makes him available for the child. Somewhat of concern is the communication between these parties. We gave you a brief sampling of some of the texts. Now, my client has concern that Mr. Lee, again, is trying to kind of impose his will on this, concerned most about his financial well-being and his financial best interests as opposed to the best interest of this child. And again, we believe that the parenting plan we have proposed gives ample time and ready time, but also acknowledges that we're dealing with a 3-year-old child who's known only mom as the primary in the primary role. So that's kind of the equalizing or the balancing act we're doing here on the parenting plan. But I think given the circumstances, that makes the most amount of sense and puts this child in a reasonably well position moving forward. If you look at, again, the financial aspect of the parties, this is 2 folks who are in very disparate circumstances. We did the best we could on our original motion to try to figure out some kind of an income for Mr. Lee. I think we're pretty close. We have taken his wages based on his bank statements and deposits from the sheriff's office, which leaves, and again, this is net for him, net deposits into his account in the amount of about $7,325 per month. In addition to that, we get the reserve pay, which is another $1,428 per month. Now that puts him at net monthly wages of $8,753. My client, she's employed on a part-time basis, 30 hours or so per week at Roto-Rooter, and makes $20 per hour. Now that leaves her with a gross monthly income of $2,580. I think if you look at child support, that is what it is based on the incomes, based on the parenting plan. But there's other factors that we're asking you to consider, most notably kind of the standard of living that these parties currently enjoy. While Mr. Lee is living on 30 acres on the Toutle River in Kidd Valley in a custom home, my client and the child are currently residing with her parents in their home in Longview. That can't continue. We are asking for family support and amount that's reasonable given the circumstances and the traditional roles of these parents. so that she can get out on her own, find suitable housing, which is safe and in a good neighborhood, for her and the child. And we think that our suggestion of additional family support, or we can call it maintenance or whatever the court directs, in the amount of $1,261 per month is appropriate, which bumps Mr. Lee's total obligation to $2,500 per month. This still puts him in a superior financial position, especially considering the fact that my client is paying her car payment. And again, we have a complete swearing match. We provided you information related to that payment, which indicates the tractor which Mr. Lee uses on the acreage up in Kidd Valley, again, is included in that. Again, we were surprised to see where he says, oh, the tractor has nothing to do with her car payment, when the information provided, which was fairly simple to acquire, directly refutes that. We've given you not only the text messages related to that, we've also given you the statements from the bank related to that, showing my client's auto payment or auto balance going from $9,000 to roughly $17,000 over the course of the month, acquired at the same time they got this tractor. So again, to suggest that those are two separate issues is not only misleading, but it's blatantly incorrect. Now, we are asking again for the financial relief as cited, also asking for a contribution towards my client's temporary attorney's fees and costs. Again, we're in this situation because these parties are getting a divorce. And again, that's not attributing blame to either side. They just couldn't make it work after a significant period of time. We do believe, based on the disparity of incomes, that's appropriate. My client scratched and clawed to try to come up with those fees that she paid me on the retainer. And we are asking, since discovery will certainly be due, we will need further information related to that home, the retirements and such. And we are asking that contributions to her fees and costs in the amount of $2,500 be ordered. Also asking that any contribution towards her fees and costs be paid within 60 days of entry of the orders. My client impresses upon me, asking that I impress upon the court, that her primary focus is on this child and making sure that this child has ample time with dad, but maintains the status quo and the recognized pattern of conduct of these people that my client has had. The child has been her primary caretaker. And again, our parenting plan certainly prescribes to that notion. Also asking if the court does appoint a guardian ad litem, that be based on the percentage of the incomes off the worksheets, which we have proposed in anticipation of today's hearing.
Counsel?
Yep. Thank you, Your Honor. So I think the most important issue in this case to my client is the party's daughter and the parenting plan, and making sure that whatever the court adopts is in the best interest of their daughter. So one area the parties have significant disagreement regarding is what is the status quo, and what has been the status quo since the parties separated. So my client did work full-time during the marriage. However, he indicates that this was not a situation where mother did all the caregiving. My client was involved. He did do a lot of the caregiving during the marriage, including the nighttime activities as detailed in his response. So since the party separation, my client has had every weekend except for 2 from Friday to Monday. Additionally, my client has just come off a stretch of having the party's daughter for 17 days from June 23rd to July 10th. So this is not a situation where he's had a few weekends since separation. My client has been heavily involved and just had 17 days of parenting time as detailed in our response. In addition to these weekends he's had from December 7th to December 9th and December 15th through December 16th. So this more than makes up for these two weekends, not 3 weekends, that he was in Texas. Mother submits a calendar indicating that these are the only dates my client had the party's daughter. But the calendar is not correct. It does not show all the dates my client had parenting time. To illustrate, her November calendar does not indicate my client had November 10th, and my client submits photo evidence that he had the daughter for an overnight on November 10th. So just on that day, we know that's incorrect. And my client didn't have photos on every day he had the daughter, but he submitted the photos that he does have. Additionally, mother indicates on her calendar that my client, or indicates in her reply declaration, that my client only had their daughter for 5 overnights in June. But even looking at her calendar, we know this is incorrect. My client had much more days than that. So this is not a situation where my client's had a few weekends a month or has not been heavily involved. My client has been heavily involved. He is also the sole caregiver of daughter's siblings, 2 teenage boys. And it's not only is it important for daughter to have a close relationship with both parents, it's important for her to have a close relationship with her siblings. And so we're also asking that the court consider that when putting in place a parenting plan. My client has been very clear regarding his work schedule. Both parties work. Both parties will periodically need care for their daughter when they work, which is normal in most situations. Most parents have to work these days. So my client has appropriate care arrangements, including sometimes a 16-year-old son can provide care, which mother has done as well. So the parenting plan my client proposes gives both parties weekends. It gives both parties time on their day off, and it breaks up the schedule. So keeping in mind that this is a 3-year-old daughter, but again, my client just had her for 17 days. So clearly mother is okay with my client having her for long stretches of time. The parties are going through a divorce. My client is, we submitted text messages that show that most of the communications, the vast majority of the communications, my client has been very nice, very respectful, very showing consideration and kindness towards mother, and my client's not indicating mother's doing anything differently. Of course, not all text messages are going to be perfect when parties go through a divorce. So my client is wanting to work with mother, and he's wanting to move forward in an amicable way. One concern that my client is requesting that the court address is whether mother is able to drive right now, and he's not saying that should affect her parenting time or anything like that. But we are asking for parameters around that if she feels like she is not in a place where she is able to drive. She has indicated previously she can't due to some eye surgery, and so we just want to make sure that this is addressed in whatever parenting plan is put in place. Additionally, my client is requesting that the court adopt his proposal regarding support. He has been paying mother $900 since separation. To clarify, $500 was cash, and the rest was payment of her expenses. So my client is being completely upfront and fully disclosing all information he has with the court. That's what that support amount was made of. He had been paying this amount by agreement. Both parties agreed that this was sufficient, and mother never requested any additional support amount until retaining an attorney. So clearly this was enough for her. When ordering support, my client is asking the court to consider that he is essentially the sole financial support for his 2 teenage sons, and he should receive a deviation in child support per RCW 26.19.075. My client does not have the ability to pay wife's requested support amount as demonstrated by his financial declaration. He did encourage wife to work during the marriage, although I recognize that these are temporary orders and this is where we are now. He is proposing, for purposes of calculating child support, mother's income should be imputed full-time at her normal rate of pay. There's no reason she should not be working full-time at this point. He submitted his wage stubs and all of his tax returns and pay information. We submitted an income calculation. His income is properly counted at a net of $8,049. And again, he's requesting that mother's income be calculated full-time at the current rate of pay. Further, it is impossible to determine what mother's financial need is. Spousal support is based on the need and ability to pay. Mother fails to submit a financial declaration. We don't know what her expenses are. We know she's currently living with her parents and that they have income that's contributing to these expenses, but we don't know exactly what the need is. What we do know is based on father's income and his financial declaration, he can't pay the requested amount. I don't know how concerned the court is about the Chrysler payment. Depending on what is ordered in support, father's asking mother pay that. I think the issue here is the language that mother used in her statements. She indicated the monthly payment was for the tractor and the Chrysler. The monthly payment is only for the Chrysler, but the parties did refinance the Chrysler. So I think that's probably the confusion in the language. My client's not trying to be dishonest with the court. One thing to note is that refinancing the Chrysler to purchase a tractor increased the monthly amounts, the monthly payment by about $68. So that's something for the court to consider, that maybe $68 of that would be due to the refinancing of the tractor, but the remainder was already a payment for the Chrysler. My client is requesting the court deny attorney's fees. He has tried to streamline this process by proposing settlement on temporary orders, proposing mediation, and mother, instead of responding to the offer or agreeing to mediation or something like that, filed this motion. So he really does want to.
Anything that's settlement related, that would certainly go towards that, as would the text message that he provided. But I'll speak to that in a moment. I just asked court not to consider anything.
I understand. I shouldn't consider negotiations between the parties.
Okay, and I apologize, Your Honor. I didn't interpret that as a negotiation, just as a, hey, do you want to go to mediation? So my client is trying to move forward in good faith. He asked that attorney's fees be denied. If the court feels it is appropriate to appoint a guardian ad litem, he has no objection to that. He proposes that the costs are equally shared, or at the very least that they are based on the pro rata percentages in his child support worksheet. Thank you.
Mr. Zandy?
And very briefly, Judge, I want to start by, some of the language that's contained in the declaration seems very contrary to what the statements now are today, almost as it's trying to correct a lot of the misstatements that I would certainly say are contained throughout his responsive pleadings. If you look, and again, by counsel's words, most recently, Mr. Lee had the child for 17 days. Wasn't overnights. Again, I would dispute the fact that that was 17 straight days, and that's not really mentioned anywhere that I see in review of the pleadings submitted by Mr. Lee. So again, that's information that I would ask the court not to consider. If you do look at what we do know, even if you throw in the extra overnight on November 10th, as suggested, that bumps him from 3 overnights to 4 for November. That's about 5 in December, 8 in January, 5 in February, 5 in March, which is about the time that he's going to Texas to see the girlfriend. 6 in April, 6 in May. We have the June issue, and then it was most recently in July that he exercised extended visits after being served with this motion, and probably in anticipation of today's hearing. Would also state, if you kind of dovetail that and take that into consideration with the text messages, that's concerning. As the court is aware, joint plans require co-parenting, effective communication, both parents having the ability to provide for the child in similar capacities, and we do not have that for Mr. Lee. All of the communications, and I was surprised counsel said they're very nice and very respectful. They're not. It's very threatening. It's very imposing. And the fact that my client asks him on one occasion, thinking that he's going to take the child on his vacation and do something fun, finds out that he actually worked a couple of those days, says, well, where are we leaving the child when you're gone? He says, essentially, it's none of your business. I've got it figured out. So the fact that we have that type of response when she's asking a very basic question shows me that the joint plan being suggested by Mr. Lee just is not going to work based on the circumstances and the significant depth of these two parties currently. That's a concern. We look at some of these other suggestions, and again, it stands out that we now have a lot of these corrective means. Counsel states, well, he's been paying her the equivalent of $900 per month. That's not what's in his declaration. In his declaration, he doubles down on that. He says in 2 areas, the amount I have been paying since separation. He then goes on and says, I have been paying respondent $900 per month in total support since October. That's not accurate. And again, the same thing with the tractor. We look at that. Counsel says, well, the car was refinanced. Again, that's not what's included in his declaration. He says the loan is only for her vehicle and does not include the tractor. I'm assuming that's tractor because I don't think the parties own a tractor. So again, if we look at the verbiage, we look at the information you do have through the text messages in which he said, essentially, you're going to stipulate what I want you to. Otherwise, I'm going to do this and that. And the attorneys are going to take all of our money and make all these kind of broad threats. Again, that is not conducive for a joint parenting plan. I think it's safe to assume, based on those communications, based on where we're at, and based on the status quo, he's making the suggestion for a joint plan, not because he wants the time with his child, but more along the lines of he wants to avoid or minimize any financial exposure he has. And it seems very clear through these pleadings to suggest that he's been very nice and very respectful. Again, I didn't read it that way. And I gave you a sampling of kind of what there was related to that. And those are not nice. Those are not respectful. Those are not ones where it says and suggests we can co-parent. Rather, it's ones where it suggests we're going to co-parent and you're going to give me what I want on the parenting plan, or else we're going to go to court. That's not a negotiation. That's a threat. And we have that repeatedly throughout. One last thing I wanted to mention, again, is that we do need to keep in mind that this is a 3-year-old child. This is a 3-year-old child who has lived a significant chunk of her time since these parties separated in October under a very traditional arrangement of dad getting weekend time with her. And again, my client is agreeable to that. There's been nothing presented that shows she's not going to be willing to accommodate extra time. She wants to do that. But for basis of a parenting plan at this juncture, I think it makes the most amount of sense to give dad his weekends. Hopefully he exercises those. Hopefully he can learn to communicate effectively and in a non-abrasive tone with her, a non-threatening tone. as well as the time in the weeks where he's at National Guard. Again, which everything she suggested in that parenting plan works perfectly to a T with his work schedule between the sheriff's office and the National Guard. Everything else, again, we believe is very reasonable given the financial circumstances and most importantly, what's best for this 3-year-old child.
All right,
Yeah,
Counsel.
I can briefly respond.
Yes, ma'am.
So, Your Honor, I do want to point out first that page 3 of my declaration, or my client's declarations, lines 6 through 8, is when he indicates he had the child from June 23rd to July 10th. So again, this is 17 days. This is not, my client does exercise all of his parenting time. 2 weekends he was out of town, 2 weekends since separation, not a big deal. He made up more of the time by having 17 days of mom's time in addition to another 3 days of mom's time. So my client does exercise his time. To indicate otherwise is frankly pretty insulting. I mean, he submitted pictures showing how involved he is, the activities he does. This is not about finances. He is not asking for the daughter because he wants to reduce his child support obligation. I think that's pretty clear in the pleadings. This is about him wanting to have that time with the daughter and wanting the daughter to have that time with her brother. So we ask the court to grant our request.
All right, thank you. Well, as is often the case, the parties kind of disagree on a lot of things getting to this point. What is clear is we've got a couple of pretty involved parents. I certainly need to foster the youngest child relationship with her siblings. That's somewhat difficult, less so in the summer, but school's going to start up again here very soon, and then it becomes something of an issue. I'm not going to order anything specific for summer, but I would think the parties need to cooperate to give those boys some time with their sister. For a 14 and 16-year-old, I'm not sure exactly how much they're going to want or how much they'll be able to put up with once you agree to it, but I'll leave that to the parties to work out. I do think the proposal of Friday at 5:30 to Monday at 5:30 makes sense given everybody's schedules. Ms. Lee has, while it's not ideal to be living with her parents, that provides probably some in-home daycare and makes it somewhat easier. So he'll have the Friday at 5:30 to Monday at 5:30, except the weekend where he's in the National Guard, and then he's got Sunday 5:30 to Monday 5:30. As I say, they should cooperate on some additional time with the brothers in the summer. The child support issue, not too much difference of opinion about everybody's incomes, but we do have Mr. Lee providing almost entirely on his own for his 2 teenagers. And so there should be a deviation for that. There's also the issue of maintenance or family support. I'm going to order total family support of $1,350 per month. That's starting July 15. Fees, $2,000. That should be paid within 90 days. Ms. Lee should be looking for full-time employment. I'm not going to put a specific timeline on that, but I think that's important. I don't see the issues as being ones that a GAL is going to be real helpful on. I think everybody says the other one's a good parent. The only real difference of opinion is that what have we been doing since separation? I don't think a GAL is real helpful in that, so I'm not going to order one at this point. And counsel, given that I'm not here all that often, if there are any issues about the language in the orders, would it be agreeable for everybody just to handle those by way of an email exchange with me, so we don't have to try and set up another hearing that will slow everybody down?
I'd
That's
prefer that Ms. Wright Reed's office and my office communicate. I would certainly think pretty well together. I think we could probably get agreed orders out on this, but just in case, yes, we're agreeable to doing that. Any remaining issues, email makes sense.
That's fine with me also, Your Honor.
All right, thank you, counsel.
Your Honor, I do, because I know this will be an issue in getting agreed orders. What is Your Honor ordering about the car payment?
At this point, she continues to make. This was initially
Okay. Thank you, Your Honor.
Ms. Jackson's motion, so ma'am, go ahead, go first.
Okay, Your Honor, I'm representing myself since I cannot afford a lawyer. I just, I don't even know where to start. My husband, I filed for divorce on the 7th of June after I was told he wanted a open marriage on the 2nd of May. And I discovered that he has been moving a lot of money around. his first financial declaration that he gave or his lawyer gave mentioned that he's making $7,000 a month, with me making $6,000 a month. I've turned in so far 2 financial declarations, which showing that I make about $2,300 a month. And he never mentioned in his income that he has actually Army retirement and disability, which brings his total to around $12,000 a month. So we're talking here about $10,000 more a month than I make. He made me move out on Sunday of the house. I've been staying in my car since then because I financially cannot afford a hotel. Besides, due to that, I had 3 back surgeries and another one coming up this year. I have to sleep either in a hospital bed or in a recliner. He had stated before that our oldest daughter had said that I could stay with her. That was falsely also. Her husband and her decided that he can stay with them. And he actually did stay with them for now nearly 2 weeks and had mentioned last week in court he's still staying in a hotel, which was falsely also. The restraining order that was against him, he came in the house, which I had proof of by pictures. He was not allowed to come in. I had returned this to the police department also. I don't want to burden my children any longer with the whole thing since my daughter finally saw her husband after 1.5 years again from Iraq. And the short period of time that he was here, they had to deal just with their parents' divorce and the nastiness and the grandchildren suffering under that. I have at the house, I have 2 Great Danes and 2 German Shepherds. He let me keep those right now at the house. Chances that I could rent a place are pretty none to nothing due to my income and due to the animals itself. I do have 7 reptiles too. He made me move them out of the residency before he took over on Sunday, which was not really, the commissioner had written in the restraining order that it will be by court, by the commissioner said who can reside at the residence, and it never got said. It just got denied my restraining order against him. My animals are my everything for me. I will have another back surgery. I said that already, but I also have on August 1st, I have major dental surgery, which means everything is going to get pulled at that point. I have out of pocket for $3,800, which I had saved up that money to put aside. He's going on vacation next week with one of his, let's say, lady friends for her 40th birthday to Mexico, to the same place that we spent our 25th wedding anniversary at the same hotel. So, I mean, this is a little bit very hard on me. Due to that, I had severe mental health incidents. I tried to commit suicide. I'm still in mental health classes 3 times a week. I can't work right now. It's not that much due to my back injuries, due to my mental health, which is like an extreme roller coaster, and due to all my court appointments that I'm having right now. So we had, with my gross income of about $1,800 a month and his income of about $12,252, we wanted that he keeps on paying the mortgage and the bills just like we had it all the time. He was the main bread maker. I was just the one who supported a little bit here and there under it. And so I just want that I can move back into my residence, since I do need my animals extremely. He's going on vacation. Who's taking care of the animals? I'm staying in my car right now. So I'm requesting, after everything is taken off, all his thing, I'm requesting of spousal support of $2,177. He also took out of our joint account, opened up another account just in his name, been moving money in there. He's paid let's say, all his lady friends, I don't want to say it any other way, since April, over $10,000 out of our joint account. Just in the less than 2 weeks, 3,200 to a lady that is in rehab, which I do not understand. But so this is what I'm requesting at this point, to be able to move back in my residence, to be with my animals, to enjoy my children again and my grandchildren, because they like to come over on the weekends. We are going to the lake and we're doing a lot of stuff, and I have not been able to do that. And I'm requesting spousal support.
Mr. Culbertson?
Yes, Your Honor. I'd like to note that my client filed an amended financial declaration yesterday, which acknowledges that he makes an additional $4,045 in combined military retirement and military disability, which brings the income to $11,885, along with his job. So what the opposing party doesn't mention is that she assaulted Mr. Jackson. She was arrested. After she got out, she went and sought a civil protection order where she didn't mention that she'd been arrested or that there was a divorce. So that was the case that was dismissed. And he wasn't even served with that. The way I found out about it is on a Friday, he met with me and he gave me paperwork, including the district court case, and where there was a restraining order against the opposing party. And somebody had handwritten in that, well, who will occupy the house will be dealt with in the civil protection order case, which was subsequently dismissed. So that protection order in district court still exists. She moved out on Sunday. He'll make all the payments. You know,
What does that protection order say, if anything, of the one that was granted? What does it say about the house or anything like that?
It said that'll be determined in case number, and then they had the civil protection order that was dismissed.
All right. So it has no other orders related to property?
No.
All right, thank you. Go ahead.
So in his proposal for temporary orders, yeah, he said he'd propose that he'd pay all the bills except for her auto insurance, but he can pay her auto insurance as well. They're on the same insurance plan. So there's going to be some kind of spousal support. I don't know anything about him going on a vacation. That's the first I've ever heard of that, but I know that he takes care of the animals. But you know, the animals seem to be a big theme here, and it's not a big thing that she assaulted him and got arrested for that.
All right, ma'am, anything you want to add?
Yes, Your Honor. So the animals, the dogs honestly are very afraid of him because of his temper, that he tends to hit after him or yells at him. The restraining order was after he hit me and falsely stated something different to the police department. He hit me, he took my phone away from me, threw it on the floor, tried to break it because I have all the evidence on my phone from all his vacation trips, everything else. Like 2 days after he told me that he wanted an open marriage, he spent over $600 already at Victoria's Secret. He booked a hotel room for almost $400 at Seaside. All of those things. And I holded on to his t-shirt and he ran, and that's how his t-shirt got ripped. He is a retired military man. He has severely PTSD. I have always been scared of him. He used to beat our children that bad that CPS was involved at one point, and I had to hide our daughter from CPS. So the chances of me walking in a room and start hitting him are really low to nothing. At the end, yes, I not insulted him, but I hurt him because in my own defense, after he had hit me, and I'm just trying to get my phone back. He then took with my phone, he ran off and locked himself in the bedroom. And that's why I got arrested. But that's a whole different case. It has nothing to do with the family law at all.
I agree. Let's move on from that.
Yeah. So I just want to go back in my house, be with my animals, and get child support. Not child support, spousal support. We've been married for 31 years.
All right, well, it sounds like the financials have gotten a little bit closer. And obviously there's some disagreement about the history. At this point, Mr. Jackson will remain in the family home. He's to maintain the house, take care of the animals. He's to provide her maintenance of $1,600 per month. And he's to maintain the vehicle insurance. If and when Ms. Jackson hires counsel in this case, he's to pay $3,000 towards her attorney's fees. But that'll only be upon proof that she's hired counsel.
Okay, so Your Honor, so for me right now, so with him even paying the mortgage and everything, I cannot go in my house.
Correct.
So it's okay for me to stay in the car with my back issues. And what is when he's going on vacation next week? Who's taking care of the animals?
Well, hopefully you will find some other place to live with the maintenance payment, and it's the animals are his responsibility. And counsel,
Okay.
Ms. Jackson did submit a proposed order. I've made a number of changes in that to reflect the ruling, and the clerk's office should be able to email both sides a copy of that when we're done.
What does that mean, Your Honor?
You'll get a copy of the order that I just signed that reflects what I just told.
Okay.
All right. Thank you.
Okay.
Okay, Your Honor, one other thing. How do I communicate with Ms. Jackson?
At this point, do you have a phone number for her?
I have a phone number my client gave me.
Okay. Yeah. At this point, she's not represented, so you're free to contact her directly. Ms. Jackson, if you do hire counsel, you should notify Mr. Culbertson or have that attorney notify Mr. Culbertson immediately. Understand that?
So Your Honor, Mr. Culbertson doesn't even has an office. He only has a drop mailbox. We've been trying to serve him there. I couldn't even find an email. Calling him up will go directly to voicemail. So right there, I have a little bit an issue with that.
Okay. Well, there's a phone and a fax number and an address on his pleadings. I suggest you use those.
Yes,
It's
Your
a-
Honor, I did, and it's not there.
It's an executive suite. She just has to call me. We'll set an appointment. We'll meet.
Well, Mr. Culbertson, we had sent 3 people over there. We had 3 people had called you up, and your phone
Ms.
went
Jackson?
directly to voicemail.
Ms. Jackson,
Yes.
Your Honor, did
call him
you
and
have
make an
a chance
appointment.
to review
Okay.
the
All right.
document I
Thank you.
submitted to, it went into Judge Evans's email because it's a photo exhibit and I can't file it.
Yes, ma'am. I did.
Okay, so we're here before the court in regards to discovery. This is a joke. I can't even read the discovery that was given. It's like done with either color crayon or pencil. I can't read half of it. This is not in keeping with the order of the court. I don't know if the court wants to have Judge Evans review this, but I can't use this discovery. I can't even read half the words on it. I've never had, excuse me?
I'd ask Ms. Fowler if she has anything to say.
Your Honor, I complied with the court's order.
Okay, Ms. Fowler.
Judge Evans ordered me to take,
Ms. Fowler, we're not even going to go there. I saw what you submitted. I don't know if you think you're being clever or funny, but that's in no way, shape, or form compliance with the discovery requirements. So the order was that you were to pay $1,000 in fees unless you did comply with discovery. So you owe that $1,000 in fees. I'm putting this on in 2 weeks, August 1. If you have not submitted proper discovery answers, it's going to be another $1,000 in fees. If you want to continue to play whatever game you think you are playing, just be aware it's going to cost you a bunch of money. The other thing that will probably happen is if you continue along this path is your pleadings are going to get stricken, and Mr. Reed is pretty much what he wants. Is there any part of that you don't understand?
the only question I have is I was ordered by the court to take pen and paper or whatever I had to write and respond to discovery. And I did. I did what I was told.
As I say, I don't know if you thought you were being clever, but that is in no way, shape, or form compliance with discovery. If you can't figure out how to comply with discovery, I suggest you talk to an attorney or contact the legal aid program. But it's obvious that you thought you were being clever or funny with this. And I'm just not going to put up with it. And there's no reason Moscoto should either. So August 1, 9 o'clock is your deadline. It's going to cost you more money if you continue to pull what you think is the same stunt. Is that clear?
Yes, Your Honor, it's clear to me Mr. Reed's gotten his way this entire time.
That will be all.
Okay, I will submit an order. It looks like, and it's difficult for me to read, but Ms. Fowler has the confidential address program, but I can't read the PO box number. Could she please provide that on the record so that I can mail her the proposed order?
What's the PO box number, ma'am?
Pulling up my crime and domestic violence card right now. It is PO Box 25716. And keep in mind, those are screened, and the ones that are forwarded do take several weeks to get to me because it is going through a rerouting program if it passes through the screener.
All right, well, I suggest you get your discovery to Ms. Cotto's office right away.
Thank you, Your Honor. I will prepare a proposed order also and have that ready for presentation on the 1st.
All right. That
Thank
will,
you.